So many thanks for making an early morning for us.
Thank you, Michelle.
So let's begin, gentlemen. First of all, with your thoughts, because this was a 12-hour-long full verdict. Honorable Kioni, what are your general thoughts of the verdict?
It's a verdict that seems to elevate the process above the will of the people, where the process is more important than the result.
Right.
I think it's something very interesting. I think that is why Wajiko here in your cartoon is saying, get your hands off me. I know my way around this issue.
That's on page 14 of the Standard. If you could have that maybe later on.
Of the Standard, maybe later on. But Wajiko is asking, what became of my vote? What became of my vote? I cast my vote. What became of it?
Right, right. And of course, that is very similar to the dissenting opinions that are given by Justices Njoki Ndungu and Jackton Ojwang. But Honorable Olwach, your thoughts on both the majority decision and the dissenting decision as was read out yesterday?
Thank you, Michelle. I think a lot of focus has already been put, like you said in the earlier show, on the majority decision. And maybe time now for us to look at what is a minority decision. But before we get into that, maybe we need to unpack what is this so-called the will of the people. It's more of the question of what came first. Was it the chicken or the eggs, or the eggs or the chicken?
Right.
I like to put it another way sometimes. Process, or do we go content and form, like Njoki Ndungu was saying? If I was to give an example from my Catholic background, you'd be talking more about the three persons in the Trinity, the Father, the Son, the Holy Spirit. You cannot remove one from the other. Njoki Ndungu talked about at the heart of democracy is the right to vote.
Right.
And at the heart of the right to vote is the people's will. Now, can you remove one from the other? We are a democracy, yes, given under Article 38, the right to vote, and then expression of the will of the people. But how do you extract this will? It's not supplanted from the blues, and that's why process becomes important. Everybody who looked at this petition seems to think numbers. Let's talk numbers. In fact, even at the end of the long delivery of the verdicts yesterday, you still had advocates talking about, yeah, we want to keep these ballots. Somehow, there is an itch to, we will go back to those ballots and open them and still count. There is a preoccupation with the numbers, which is important.
Right.
But that's not the case that went to the Supreme Court. That was the case that went to the Supreme Court in 2013. That has been the Commonwealth tradition for very, very many years, what has come to be known as Morgan versus Simpson, that it does not matter how you get the vote, just get it.
Right.
But then, when you're talking about the will of the people, it is possible either way to subvert the will of the people. If at the end of the day, like they said in their dissenting opinion, that Wanjiku and Kamau and Olwach queued for long hours, voted, and then you go and change that decision. But it is the other way. If the same people went and voted, and using flawed processes, you go and overturn that decision. Last overview that I want to make. People have derogatorily referred to the judges as these 3 men and 1 woman. These 4 people have taken over the will of the people and decided they're the ones who will decide the president. But let's look at this thing from the context. Article 1 of the Constitution says that the sovereign power belongs collectively to the people of Kenya. Right. And it is devolved. It is expressed and exercised by different people. Among those people who exercise that right on their behalf is the judges. And you go back to how judiciary is formed. They say that judicial authority emanates and belongs to the people of Kenya. So the judges sitting there may be 4, but remember, they are also exercising a portion of that sovereignty. So let's not be very selfish about this sovereignty and take it to some corner and say, look, what happened to 15 million votes of Wanjiku? But how does that will get expressed?
And they will be
That's where the detail,
a little more on the dissenting opinions as we try and put some context into that. But even on the issue of numbers, remember Chief Justice David Maraga there emphasizing quantity, quality rather, over quantity. But let's take a look, just before I come to you, Honorable Kioni, at the condensed view of what some of the judges of the Supreme Court had to say, beginning with the judges upholding the majority decision there. Chief Justice David Maraga, Deputy Chief Justice Philomena Mwilu, Justice Isaac Lenaola, as well as Justice Smokin Wanjala, who was not present in court yesterday. So that is Chief Justice David Maraga saying an election marred with illegalities cannot be respected as representing the majority will of the people. And the majority, 4 judges here, said it's about the entire process, not about the end of the result. Later on, we'll see Deputy Chief Justice Philomena Mwilu saying an election is just like a math problem. You must show your answer with the process of how you arrived at the answer. Honorable Kioni, let's talk about this and your thoughts on this particular decision. An election marred with illegalities cannot be respected as representing the majority will of the people. Massive illegalities were pointed out.
One is it would have been useful for the judges to list the illegalities. And that was lacking. We did not see a list of the illegalities that had been committed so that to invalidate the will of the people. And I think there is something that I need to say in response to what he has just said. When you go into the polling station, what Wajigo did was to cast the vote. Right. At the end of that process, the vote was counted. It was tallied. It was verified. That polling station, the winner was known. From then on, it was the question of taking the winner to be declared to Nairobi. Right. We then said the process of going to Nairobi is more important than what we had already established at the polling station. So it is no longer important to get a winner at the polling station. What is important is how you move from my constituency, Daragwa, to Nairobi. To me and to the Wajiko, I think it is a silly argument. Right. It may make sense from the courts of law, but for the person voting, and that is why Wajiko is saying, get your hands off me. They are dirty. I know what I want. Right. I have decided who is going to lead the country at that polling station. When then judges sit, and it is important to say this, it is actually Raila himself who said, 7 men cannot decide the will of 15 million people. I mean, he's the one who started demeaning this. But it is, why it is crucial to me that you cannot be seen to be taking that way, what this person intended to do at the beginning. And then you say, they are irregarded. You remember, this is another thing that I want to bring out. During the summary judgment, or the short form judgment that was delivered, I think, on the 1st of September, we were told there were irregularities and illegalities. And we expected yesterday a list of the illegalities. What eventually came out was irregularities and not illegalities. Right. And even now, he's saying you cannot take away the will of the people because of a list of illegalities. This judgment fell far short of what we expected. Right.
Just before you continue, in IBC's defense, take a look at the front page of The Nation. Maybe you could grab that. That yellow box right there is detailing some of the irregularities and illegalities that the Supreme Court found on the part of the Independent Electoral and Boundaries Commission. One of them was announcing or declaring President Uhuru Kenyatta a winner with a Form 34E that did not have, 34C rather, that did not have security features. But it is also putting the IBC on the spot for failing to verify the results that came from the constituency level. But maybe just to get more into his argument, Honorable Oluwach, this was a decision that was decided by the court with regard to the minor Kiai case, that results at the constituency level will be final. And many legal experts said then that completely ties the hands of the IEBC in terms of verification, because the decision has already been made that any Form 34A coming from the polling station then is a final result.
Just before that, can I just say this so that he can respond? You are telling Wajiko that if you record my vote on this piece of paper, which is not the same size as this piece of paper, it is no longer valid. The sizes of the papers must be the same for what is written to make sense.
Right.
To Wajiko again, it's a serious argument.
security features, Honorable Kiod.
Okay.
Yes, but what is important is what is written there. It is not the size of the paper or the color of the paper.
Very well.
I mean,
okay, the arguments are not as straightforward, black and white, or simplistic as they look. The Maina Kiai case, and it would be good that we read the long version of Justice Njoki Ndung'u's opinion on it. I was there. I was part of the Maina Kiai case, both at the High Court and the Court of Appeal. I think the decision in that respect as to whether IEBC's hands are tied has been misconstrued. I think what was before the High Court and it went to the Court of Appeal was this, Section 39 of the Elections Act. When results have been cast and tallied, the decision or the declaration, can you make any alteration as opposed to verification when you come to the national level? I think what the Court of Appeal was saying is to cure the mischief during Kivuti's time, when returning officers would disappear, switch off their phones, and then the chairman of IEBC would say, I don't know where they are. I don't know where the results are. Somewhere in between the expression of Wanjiku's will, howsoever expressed, those forms were being cooked. Now, that thing has not ended. So when my senior here holds the two papers, it's good that these two papers, whether it is square or rectangular, should not change what Wanjiku said. But remember, there was a mischief. Look at what happened in from 2002 going forward. These results were being altered after Wanjiku has made the decision. And presidents have been elected on the basis of these manufactured, altered results. Right. So Maina Kiai case came to fortify and to put seals and plug in those loopholes where those results can be changed, so that IEBC's hands cannot be said to be tied. The returning officer's hands are tied to the extent that you cannot alter. You have made the result, it is 540 in this polling station, scan it and send it as is, isn't it? Let's go now to Article 138 of the Constitution, 3C. IEBC, after receiving the results, it will do a summation of 290 constituencies as they have been scanned. What they cannot do, and the long text of the Maina Kiai case is, without addition, without subtraction, without multiplication or doing anything. But you still have to verify. The reason you have to verify is this, because Article 138 says, for you to be able to declare president, there is a test that must be met. The person must have met a certain threshold, which is 2/3 of the counties, isn't it? So that requires that at least you use your mind and verify that these are 290 constituencies, you meet the threshold.
Right.
So that is important for us to be able to understand.
All right. Honorable Kunin, even as you add on to that, taking a look at some of the issues that have been pointed out by the majority decision on the IEBC, why would you not refer to these as illegalities?
Now, before even that, the unaltered results, where nobody has touched anything, is still available at the polling station. That document that was verified, entered in the few gray of the public, is still at the polling station.
All right.
Why is it that the court did not find it necessary to go back to the polling station and recount? We can deal with the transmission, we can deal with the complementary processes and improve them as we go along. It is important for the country. But why nullify the will of the people, which is still intact in the ballot boxes? And they're still there, sealed. That is unfathomable. Right. The fact that we never allowed, the court found it necessary to order everything else, the scrutiny of everything else, but not ballot that was cast.
Michelle, I need to intervene on that.
And that is very important.
I need to make an
Just a moment.
important
Let's hold
intervention
on that, because
yeah.
we'll be taking a look at that in more detail when we take a look at Justice Njoki Ndung'u's dissenting opinion, which largely touched on the same. But let's focus on the method of transmission, which also largely took center stage in that full verdict. Deputy Chief Justice Philomena Mwilu had quite a lot to say with regard to the transmission of results as occurred, and she said the election was neither conducted in accordance with the Constitution and neither was it transparent or verifiable. She says there that IBC showed reluctance also in complying with court orders that asked for access to their servers. And once again, this comes to an issue of transmission. Honorable Kioni, let me begin with you, because the dissenting opinions largely defended the IBC on this one. And
the dissenting opinion was that in their view is that all the orders that had been issued by the court were complied with by IBC. And again, it is important to note that there wasn't enough time for the respondents to respond to the orders and even what came out of the scrutiny. The time that was given, I can't remember very well, but I think it was some minutes, if I'm not wrong, which was given to the respondents to respond to the scrutiny. It will be important to continue looking at the specific orders and whether they were actually verified in line of what Njoki Ndung'u said. But I still want to say this. It is important that the servers and everything is available to us. And we're able to verify and to scrutinize and see what is it that actually happened. But...
So you do agree that was an illegality or irregularity on the part of IBC?
Irregularity. Not illegality.
All
you know,
right.
when you say something is illegal, there must have been a legal provision requiring you to do that. When you're talking about the security features, was it a legal requirement that every of the forms had to have a security feature? But when it is just part of the regulations, then it becomes an irregularity.
Right.
And I think the IBC needed to comply with what had been ordered by the court. Their failure to comply was then used to take away the will of the people and to punish the winner who had campaigned and done everything else that was necessary to secure the win. And for that reason, you are penalized for that. I don't think that was fair.
Right.
Okay.
Let me begin with
the issue of illegalities and versus irregularities. I think the impression has been given that these prescribed forms, the security features, were not statutory and therefore could not form the basis of nullification of the will of the people. So let me just try and debunk this by starting with Section 39 of the Elections Act. Section 39, which is how the expression of the will of the people is conveyed. This is a conveyor belt. You cannot know the result properly unless you follow the conveyor belt. It cannot be that you can use... You put a conveyor belt here from the airport, so put your bag here, go get it there. You cannot go through another process. Section 39 of the Elections Act says that the votes have been counted, they've been tallied, they shall be transmitted in a prescribed form. That prescribed form is called Form 34. How do they prescribe it? Go to the schedule. You go to the schedule, it has been described how that form looks. Now, they say that the regulations do not say, or the Act does not say have security features. Right. But then, in order for that prescribed form to actually go to the printer, they had a contract. We attached this contract to the Supreme Court documents. The contract between the person who printed an IEBC was that it shall have the following security features. So that when you're reading the law, prescribed form is 134, meaning you cannot express Wanjiku's will by Form 37 and then say this is presidential election results. The mischief there is that when you look at some of those forms, some of them written Uhuru Kenyatta, Kenyatta Uhuru. The format, if I decide myself and I was a candidate in Mathare, that I want to try and play around monkey business, I go print some ballot papers, and if people voted to the extent of 10,000, I go and print forms and come and say it does not matter how the result has been in whatever form. And I come with another very shoddy form. They were serious changes. It is not an irregularity. It is an illegality. The form is prescribed in section 37. The format is in the schedule. There is a contract that now gives the nexus between the section and the law. Now, let me finally tie this to the provision of the Constitution, which makes this an illegality. We start from Article 2 of the Constitution. Very briefly, it says that the Constitution is the supreme law of the land. Anything that is contrary to the Constitution, an act or an omission done contrary to the Constitution, is illegal and null and void. So you don't even have to go further than that. It is illegal. And we demonstrated the illegalities. The forms were prescribed in the section. There were the regulations. There was the schedule. There was a contract. You cannot go outside the ambit of these four corners of how the expression of the will of the people was supposed to be expressed.
Does not seem to agree
yes,
with
because the will of the people is... The Wajiko expresses his will on the ballot. What is done after the ballot is by people who can choose to even compromise the process so that then the court can come, and like as they said, they can come back again and nullify the election.
Right.
We want this will of the people expressed on the ballot, which has security features, has serial numbers. If that ballot has a problem, then we can say the will of the people.
Is it possible that ballot papers can also be circumvented?
Why is it then that we did not go to the ballot paper?
Because
if it is a ballot paper that we are voting, I would have no problem. But if it is a document that is issued by others who can do it maliciously for purposes of nullifying the election later, and in any case the judge is promised and said,
right.
If again this process is messed up by employees of an organization, the will of the people will never get known.
Honorable Kioni, on that point, are those several irregularities that had been brought up in terms of, in some polling stations, the presidential vote was much more than the votes that had been cast for the other
that's
positions.
Where the point is.
Just not very long ago, just after the election, we had a case in Embakasi, I believe in Embakasi East or Embakasi South, Embakasi East, where a particular polling station was visited by alleged IEBC officers who were found later on tampering with the content of the ballot boxes, and they were not...
They had over 1,600 ballot boxes, and in one polling station, where the maximum you can vote is 700, 1,600 people voted. So this preoccupation with the ballot and the ballot itself.
Just like the
Can I finish? Can I finish?
Can I finish? And the signing of the form.
Can I finish? The preoccupation with the ballot must take into account that there have been demonstrated evidence. People who voted over 200% in excess of registered voters. So that the ballot itself cannot be the only measure of the expression of Wanjiku's will when that has been shown to be capable of being manipulated by staffing.
Right.
And putting additional votes.
There you are. He's just talked about staffing. I would be very happy to see these specific areas where the staffing was done, where the ballot papers were not in conformity with the requirements of the law and they were illegal. And then we'll be able to say these 20,000, 30,000 ballot boxes or ballot papers are not supposed to have been there. Subtract it from the win. Right. Add it to the RUSA. See whether the maths still add up. I think, and it is important to point out this.
One of our viewers,
yes, but I want to point out this.
If you count the votes, will you also count the votes from the 600 ungazetted polling stations?
Well, which were these ungazetted polling stations?
We listed them.
Was able to tell us, and we, as I said, in the course of time, in another maybe 1 or 2 days, we'll be able to go through these judgments in detail. She was able to demonstrate that I think 5 of the constituencies where discrepancies were pointed out. Kisauni, it was Kisauni, Nyali, Likoni, Mandera South, Isiolo, I think Isiolo, Mandera South and Isiolo South on Osage. That she went through the forms. And what was brought by IEBC was in conformity with what was actually required. What was alleged by NASA was actually not true. It was inaccurate. Right. So there are a lot of inaccurate statements that were thrown out there, and the court allowed itself to use those statements that were just flashed aloud without going to the detail of examining, and you cannot talk about time.
All right.
Because if she was able to do that within that time, why is it that the other judges were not able
All
to
right,
do it the same?
Gentlemen, let's pause it there and
Why
take,
is it?
take a short commercial break. I beg your pardon, Honourable. At this point, we'd like to release our viewers watching us on KTN Home. Life and Style is coming up next. But this conversation is continuing after this short break on KTN News. When we come back, we'll be focusing more specifically on the dissenting opinions by Lady Justice Njoki Ndung'u and Jackton Ojwang, as well as reactions coming from different political players after that Supreme verdict. Do stay with us.